Hi, everyone. Welcome to the 2024 Legal Issues Masterclass. We're really pleased to welcome everyone here tonight in person and virtually on Zoom. I'm Vinnie Yoon. I'm a Senior Communications Officer at the Law Society of BC. If you've sent a media inquiry to the Law Society in the past few years, it may have been me or Christine Tam, our Director of Communications and Engagement, who have emailed you or spoken to you on the phone. So I'll be moderating tonight for this workshop. First of all, I'd like to acknowledge that we are on the traditional lands of the Coast Salish people, in particular the Squamish, Musqueam, and Tsleil-Waututh First Nations. And for those of us joining on Zoom, we invite you to take a moment to acknowledge the traditional lands that you're on as well. This event is a partnership between the Law Society and the Jack Webster Foundation, and we've partnered to put on this event since 1994. As journalists, you're probably familiar with the work of Jack Webster. Some of you may have attended the awards dinner in the past. You may or may not be familiar with the Law Society's role. So the Law Society is the regulatory body for lawyers in British Columbia, and our role is to protect the public. We set and enforce professional and ethical standards for lawyers. We also bring a voice to issues affecting the justice system and the delivery of legal services. We're governed by a board of governors called benchers. 25 benchers are lawyers and elected by other lawyers across the province. 6 of those benchers are public appointees. They're appointed by the Lieutenant Governor and Council to bring their expertise not only to the decisions that are made by our board, but also to our discipline hearing panels and our committees. Jack Webster served as a bencher of the Law Society, and in fact, he was one of the first 2 benchers to be appointed without a legal background. And his legacy today continues with the Jack Webster Foundation. So without further ado, we'll start tonight's program. We're going to be walking through a scenario where you, the journalists, will be reporting on a criminal trial. And along the way, our panelists are going to weigh in with their expertise. I'm pleased to introduce you to our panelists. First, we have Rhianna Schmunk, who's a senior writer covering domestic and international affairs at CBC News. Her work over the past decade has taken her across North America. She routinely breaks news from the courts and the broader justice system in British Columbia, with a particular focus on prominent civil cases. She strives to make the courts more accessible by translating complex legal materials into clear stories, explaining the case's effects on daily life. Her work has appeared on Front Burner, The National, and What on Earth, which is CBC's Climate Solutions podcast. Rhianna has previously contributed to Global News, HuffPost Canada, and Monte Cristo magazine. She holds a journalism diploma from the British Columbia Institute of Technology. Next, we have Scott Dawson, who's a senior litigator and partner at DJA Counsel. I'll make it brief.
Jump to the end.
For decades, he's advised regional, national, and international news media organizations on disputes ranging from court openness to intellectual property issues and defamation claims. He's also an adjunct professor in the School of Journalism, Writing, and Media at UBC and a contributor to continuing legal education programs. And Scott was called to the bar in 1995. Rumina Daya is a senior reporter for Global News with a passion for investigative news and expertise in covering BC courts and the justice system. Her journalism career spans over 2 decades. She's an award-winning journalist who has covered stories all over the world, including femicide in Peru, the war in Afghanistan, and the tsunami in Sri Lanka. She's produced 2 documentaries for Crime Beat, a true crime series, which takes viewers deep into some of Canada's most infamous criminal cases. Originally from Calgary, she graduated with a communications degree majoring in journalism from Mount Royal University. Last but not least, we have Daniel Coles, who's a lawyer at Owen Bird Law Corporation. He acts for clients from a wide range of industries with an emphasis on media and defamation law, construction litigation, and helping licensees in the hospitality sector. Dan is an advocate for freedom of the press and other media He regularly works with journalists and national and international news organizations to obtain access to court exhibits, in-camera court proceedings, and to oppose publication bans and sealing orders. Dan was called to the BC Bar in 2012. Thank you to all of our panelists for being here tonight. And just a few more housekeeping details before we start. This is being live streamed right now on Zoom, and it's also being recorded. We're going to post the video on YouTube and on our website after this. There will be time for questions for the panelists at the end. So those of you who are attending in person, if you could just hold your questions until the Q&A. And then those joining virtually, you can just type your questions into the chat, and Christine will be monitoring the chat for those questions. And if you are on Zoom, please keep your mics on mute throughout the workshop. So we can get started. So this is a fictional scenario. You are a true crime blogger, podcaster. Notorious racketeer Mr. Frump's jury trial is about to start. He is standing trial for murder, stabbing a Mr. Bence in the back. Initially, there was local media coverage about the arrest, including a now infamous perp walk photo, but it's all been out of the public eye since. On day one of the trial, you show up on the first day with your notebook and you're anxious to take accurate notes, but you can't keep up with the pace of everyone talking. Can you take out your cell phone and start recording? So now we have a little poll for everyone. You can go on slido.com and just type in the number or scan that QR code if you are able to. And we'll be launching our first question. Does everyone have trouble getting in? No, we're good. We'll just give maybe 20 seconds for everyone to get their answers in, maybe 30 seconds. And if you could keep it up in your browser on your phone as well, we'll have several more questions as we progress. We have about 41 answers now.
If anyone, why don't I get going? That
Yeah.
breakdown looks, can everyone hear me in the back? Yeah, okay. So Vinny, thanks very much for that very generous introduction. So we got a fact pattern here, Mr. Bence, having a bit of fun with AI and my limited creative powers of narrative. But I think this is a pretty standard fact pattern just generally that is, as journalists or bloggers or podcasters you might encounter, which is there was a big crime. Everyone in town or across the province or across the country seemed to know about it at the time. There was some photos, there was some limited information. It certainly wasn't, in this case, secret that there was a murder or stabbing in a bar. Okay, now people can really hear me in the back of the room. So as I was saying, it's not uncommon for there to be some sort of crime or incident of great public interest that after the handcuffs go on the perp and the crime scene tape comes down, sort of disappears from public view while the police and the Crown do their important work. And then some months or years go by and suddenly there's a trial. And the start of that trial isn't necessarily publicly announced. Maybe you got a tip or you have some other source of information, but you find yourself day one of a murder trial. And the polling question was about an 80-20 split between yes, accredited media can record, and 20% of people said no, they cannot. So the correct answer, which we will get into in a moment, is yes. One of the perks of being accredited media is you can record court proceedings, not for broadcast purposes, but for the purpose of correcting your notes. 20% of people didn't know that. So already, if you're within that 20% group, you're learning things tonight, which is really great. So to unpack what it means to be accredited media, which I think is sort of foundational for this presentation, which is a brass tacks, back to basics, how to be a good journalist, how to get the most information out of the court system as you possibly can, get accredited. So Vinny, maybe we could have the next slide on that process, and we can hear from two of my colleagues who are on that committee on how that works.
Yeah, so this is the media accreditation process. Let's open up that link here. Just need to share the screen.
I tell you what, Vinny, why don't we don't click on those links for this particular one. We'll just read the slides, then we'll
Sure.
let Rhianna and Rumina talk about it.
Yeah, so accredited journalists and lawyers are able to use electronic devices to send or receive texts in the courtrooms of the Supreme Court and the Provincial Court. Accredited media are permitted to audio record court proceedings. The audio record may be used only for the purpose of confirming the accuracy of notes taken and may not be broadcasted or used in any other way. There is an accreditation committee comprised of professional journalists who will receive and respond to requests from media personnel who wish to be accredited. And all journalists who wish to receive media accreditation should first contact a member of the committee who will then refer qualified candidates to the courts for processing. Who should persons contact and how?
Okay, thanks, Vinny. So I asked Vinny not to hit on the hyperlinks, but on the BC Supreme Court website, there are two policies here. I encourage everyone to have a look at them if you're not familiar with them. One is the use of electronic devices in a courtroom policy, and the other one is the BC accredited media policy. So on that latter point, Rhianna, who is on that committee, what can you tell people tonight about what that committee does and how to get accredited if you aren't already?
Yeah, essentially, the committee is really just responsible for vouching for people who want their accreditation. So that's just a process where we make sure that the people who are applying for media accreditation are actually members of the media who are working today. Just because it's not a pass that's meant for the general public, we want people to be active working journalists. Largely, people who contact me are people that I already know, that I've worked with before in some capacity, or colleagues of mine at the CBC. So the process really quickly just looks like sending me an email saying, hey, I either want to renew my accreditation or get a new pass. I then send an email to the accreditation team at the courthouse and say, hey, just connecting you with so-and-so who'd like their pass, vouching that they're legit, if you can help them out. The accreditation staff at the courthouse will then send you the paperwork to fill out, which, as Dan said, explains the rules, the electronic devices policy, the rules around recording, all things that you really need to know in order to be, an abiding by the rules member of the media.
If I'm in journalism school and I email you, will you give me accreditation?
I think I would want to chat, to be honest, with you first, but that can be just a quick call and just say, how much time are you going to spend? What area are you interested in? Just because I think it's helpful to get that introduction, potentially a walkthrough. I've done that with students in the past where you meet them at the courthouse and give them a little bit of a tour. And I think that's just I wouldn't want to give someone that pass and then just kind of let them try and figure things out themselves. I think it would be nice to also provide a guidance role, but that's not required, but that would be my preference.
And you're reporting
yeah.
for, sorry to jump in.
No, do it.
Thanks for coming, everyone, and everyone online as well. So nice to see, refreshing to see this interest in legal journalism. We're a dying breed. And so I was just going to say that if you are a journalism student and you're covering the courts for your paper at your college or university, I would consider that.
What if I'm a blogger? What if I have no formal or traditional training in journalism? Does that change the answer?
It depends if you're a working journalist and you are actually covering court. Anybody from the public can walk into a courtroom and participate in the proceedings. Anybody from the public can make an application for exhibits in a murder
Okay,
trial.
we're getting ahead of ourselves.
So I'm
here.
just saying,
Let's-
so it depends,
Okay.
right? And what do you need it for, right? What do you need it for? Why do you need it? How, do you cover court on a regular basis? Like, these are discussions that we can have. You don't have to be one of the big news organizations in order to qualify for accreditation.
Right, and that's the takeaway. See Rhianna or Rumina afterwards if you have more specific questions about it, but get accredited. Okay, Vinny, let's move on to day 2.
All right, day 2 of the trial. How do you strike up a relationship with Crown, defense, court clerks, and sheriffs? And why is this important? The Crown has tendered a book of photos that includes the alleged murder weapon and the scene of the crime, and cell phone photos taken by persons in the pub shortly before and after the event. You desperately want copies of these photos to publish on your blog and to use them to promote your podcasts. How do you go about getting them? So if you go, we're going to have another poll here. So if you go on slido.com and put in 1576008, how do you obtain access to trial exhibits? So the options are: forget it, you can't have them. You must fill out a specific form. You need to hire a lawyer, or you need to ask Crown Counsel directly. Looks like you must fill out a specific form as
I mean, depending on the situation, all
80%.
4 answers are correct, really? Okay, it looks like another 80-20 split between fill out a specific form and ask Crown Counsel directly. You guys all remember those multiple choice answers in school where it was the more correct answer is the correct one. Filling out a specific form is the more correct answer, and we will get to that form in a moment. But it's good, again, that 80% of people here online understand that. And again, for the 20% of people who thought you could ask Crown directly, well, yes, that's not a bad way to start. Most Crown are going to tell you, I'm not giving you anything until the judge has okayed it. So in this scenario, Lizzie is at court and she doesn't have Coles or Dawson doing her dirty work for her. She needs to figure out how to get these photos that she really wants for her blog. So Rumina, starting with you, how do you go about building that rapport with counsel or clerks or sheriffs or any other sort of justice system participants so they are more inclined to tell you what exhibits are coming, their position on giving you exhibits? Maybe you need an exhibit list just so you can figure out what number that crime scene photo is so you can put it in form later. I mean, is it important to establish rapport? How do you do it? When do you do it?
So 100%, it will be your ally to establish rapport. If you know you're going to be covering the trial on a Monday, it would be ideal to reach out to counsel before the trial begins. Introduce yourself. Sometimes you're spending months in a courtroom with these people. And while they're conducting the trial at the courthouse, as a journalist, you're conducting the trial in the court of public opinion. So it's important that, for me at least, it's important that the public gets to see everything that the jury sees in an open courtroom. It's important for context. Some of these cases are, they make international headlines. And so, and people just can't take 2 weeks, 3 weeks, 9 months off in order to sit in a courtroom. So they need to have access to the evidence. And so introduce yourself to Crown. If you haven't been able to do it before trial, introduce yourself to Crown, introduce yourself to defense. The court clerk is probably your most valuable person in your courtroom because she has a direct line to the judge. So you want to know who all these people are, introduce yourself to the sheriffs and get emails, get phone numbers from them, co-counsel as well on both sides, defense and Crown. Sometimes lead Crown is super slammed trying to conduct a murder case in front of a jury. They're busy, so they don't have the opportunity to answer every question you have. So co-counsel is super valuable in those instances where you can get help, not legal advice, but you can get help from them navigating. Find out from them early on, day one. Do you have, for me, it's important, I need pictures, I need video, I need audio for television. So I want to know, how many exhibits do you have? How many photos? How much audio? How many videos? Are any of them controversial?
Yeah.
Is something, do you have video that both sides take no position on? For example, the suspect walking down a hallway. If nobody takes a position on that, great, put that on your list. That I'm not going to have an issue with this. So find out what's controversial, what isn't. And if something is considered controversial, where either counsel says that they would oppose, find out why exactly. You have to know why, so that if the time comes and you're able to have thousands of dollars to hire a lawyer, you can inform them so that they can form their argument. And if you don't have that money and you have to represent yourself, then at least you can try to come up with something to answer the why, to address the concerns of the court.
Rhianna, we had a chat last week and you told me about your walk and talk technique.
Yes.
How do you corner counsel outside the courtroom?
Yes, I was going to say to Rumina's point about how busy counsel are, especially if they're in the thick of a trial, they might be getting 5-10 minutes on their break. I'm sure, Scott, you've had that situation where they have a chance to run out and get coffee, or that's their first time to eat that day. They're not going to play ball with you if you stop them and say, hey, can I sit down for 20 minutes with you at that point to get that information that Rumina's talking about. The other thing to keep in mind generally is that lawyers can't really bill for the time that they spend talking to you about that stuff. So that informs a lot of my interactions with lawyers, is to keep it brief, be organized, ask them tight questions, and be mindful of their time, because they're generally not, they don't have 15, 20 minutes to spend answering every single little question that you have, which again speaks to the value of talking to them before the trial starts. I would say the second thing that is valuable about building that rapport is if you have limited resources and you're not able to attend a trial every single day for months and months and months, you could get an overview from that Crown counsel or co-counsel about, hey, when do you think the big day of this trial is going to be? If I have to pick and choose what day I'm going to go, they might be able to give you a general rough overview, or like, what days are we going to be dealing with,
The big witnesses.
the big
exhibits,
witnesses.
yeah.
You can get all of that.
Yeah.
Yeah.
Okay, Rhianna, thank you. Can we move to the next slide, Vinny?
Getting exhibits. Does the court have a written policy on accessing exhibits?
You better pause it. Yeah, pause the
Yeah.
slideshow there. Yeah.
We are going to have another poll. So if you go on slido.com, there's a number. And we've launched that third question, so you guys can vote. Does the court have a written policy on us accessing exhibits? No, it's a matter of established practice and the common law. Yes, and it's comprehensive and accessible. And I have no idea which is where I would vote.
This is a really good divide. Seems about half the room is familiar with and is comprehensive, and then the balance is all over the place from I have no idea to it doesn't exist. It's about established practice. And then I'm of the view that I'm familiar with it, but it's useless. Vinny, maybe you could run us through the rest of the slides, and then I'll get Mr. Dawson to weigh in on the tomb in his hand.
Yeah, so the Supreme Court of British Columbia does have a policy on access to the court record. It's a 49-page document. It covers access to the court record, criminal proceedings. You must complete and submit a request form to request access to court exhibits in a criminal proceeding. This enables the court to consider the competing interests in respect of public access, distribution, and broadcast of court exhibits.
And then Vinny, we'll work through the pro tips on the panel, I think.
Okay.
You can put them up,
Okay.
but you don't need to read them. So there is a written policy. It's 49 pages. There's a link here. Just thinking of time, I won't ask Vinny to turn it up. But again, this is another court document that everyone here should be familiar with. It's on the BC Supreme Court website. You can Google it and find it. There's also a request form. So we've got some examples of a request form on the next slide that we'll look at. The one in particular, I think Scott filled out. But before we talk about this specific form that Lizzie Gumshoe here is going to fill out to get an exhibit, Scott, maybe you could just at a high level talk about what is or isn't set out in that 49 pages, what people in the room generally need to be aware of. Is there anything that's going to help them in that policy? Is there anything that's going to trip them up?
Sure. Microphone's not working, but I'll speak up. Good evening, people. I see some familiar faces, some people I've acted for in the past. It's nice to see people out tonight for this. And online, I guess that's the way of the world these days, to join these things online. So good on you guys for joining in online. The policy. We're broadcasting this on YouTube, are we?
It's recorded and it'll be put up.
So the
on
policy.
I was going to preface his comments now.
Yeah. So it has pure motives. It has a tendency, in my view, to become a thickening of the border between a journalist and access to exhibits. Policy provides some direction for court staff. I'm going to come back to that in a minute. Different courts have different policies. They all kind of are set up the same way. They start with, we believe in free speech and we believe in access to court records and court openness. And then there's quite a surprising number of pages which say but. And you're going to be dealing with those pages most of the time, I think. The process, as I said, pure motives, it just in its application, it can be a bit difficult. Let's just for a minute talk about the poor court staff hired by the province. You don't generally come from some other court, so you're probably new and your training has happened only in this court. And someone says, I want that exhibit. What do? Well, if you don't have direct guidance, you don't know what to do. And in some cases, where there has been an order saying restricted access to this exhibit, you apply that across the board and you say you have to apply. And so the policy does help in that way. It does sort of give you something to point to and say, no, this is a criminal case. And on page 8, it says I can request these things and so forth. So again, with good motives, the policy was introduced. And I guess the last thing I would say about that is that policies, they change all the time. So you can't print one out and expect it to be the one that's in force when the time comes. You should always go and have a look. Make sure you're working from the right policy, okay? I tried to have the policy declared unconstitutional in a case for Post Media and CBC. It was a spectacular failure on my part, but I tried. And so I would say, the policy is useful. You should read it. It does create the forms. The forms are theoretically supposed to help you expedite getting records. Sometimes they do. In controversial cases, maybe they won't, but at least the policy is something you can point to say to the poor provincial employee who is 3 weeks into the job and being asked for the video of the murder, from closed circuit TV that was marked as an exhibit. It gives you something to point to and say, no, I should be able to get that. And so it's helpful in that way, and you should use it in that way, but just don't expect someone to just hand it over when you ask nicely for it and point to the policy. It's a really good anchor. And again, if you don't have the benefit of counsel, you're on your own. It's a starting place, right? You can pull this policy up on your phone while we're talking, and it lists all the different types of exhibits, all the different types of civil trial, family trial, criminal trial. And you can find what you're looking for and say, aha, okay, I'm allowed to ask for this. The judge may have to,
weigh in on whether I'm going to get it, but at least I can go up to the clerk and say, I've got a starting position, right? I'm not just kind of flapping in the breeze. And then as Scott mentioned, there is a form, it's a request form. There's a hyperlink there. I won't ask Vinny to click on it because on the next slide, there's a filled out example that we can look at in a moment. But these are the building blocks for Lizzie Gumshoe here. She's got the policy. Okay, great. I can ask, that's fine, you can look that up. I can ask for these photos. There's a hyperlink to a form. Okay, I can fill these out. Starting to get some momentum. Not particularly complicated. I mean, the road ahead is going to be hard for Lizzie, unfortunately, but she's on the ground and moving. So what we have behind us is two forms. They're probably a little bit blurry as far as actually what's written there, but it's good just to be familiar with these forms. The one on the left is a form I prepared for Global before Justice Devlin in a matter called RV Regis. And then on the right is a access form that Mr. Dawson handled in the Court of Appeal. And the Supreme Court form is substantially the same. So let's talk about the access form first, and then we'll talk about how you file a requisition second. Scott, do you want to talk about the access form?
Well, yeah, I sure do.
Ian Mulgrew is the name most
Yeah,
people in the room probably know.
So Mulgrew filed this and it's in the record in the Moazami case. And so I thought that was a good one to bring. I have an interesting question. I don't know how many of you go to the registry and look at records, but I have yet to see one of these forms make their way into the court file. So I actually don't know what becomes of them when you file them. So that's the first point. We don't really know what becomes. It will go initially to the parties that will make the determination about whether to oppose or allow you to have the access, but I don't know what becomes of them after that. Have you come across that before where
Well,
it's just?
Sometimes they disappear
Mhm.
and, not accusing anyone of anything, but sometimes they do disappear. And, you're 3 months into a case and you're still looking for those crucial pictures and you still don't have them. And so what I always do to ensure that doesn't happen is once you file an application, copy to defense, I give a copy to Crown, I give a copy again to your most valuable person in the courtroom, the court clerk, because the registry has the one and you make sure you get it stamped. And then I circulate that document to all counsel.
It's an unusual animal. It's a bit of a unicorn. I don't often see it. I don't think I've ever seen it in a court file. I just don't know what becomes of it. It may be it's disposable once it's addressed. But I just wanted to point out, and again, the forms are slightly different and you probably can't read this from as far away as you are. But there's a couple of tripwires at the very beginning. The first is, where is the file you're looking for? If you're covering a trial, as in this one, it's pretty obvious. You got a file number. It's pretty easy to see on the list in the day. What if you're looking for an ITO and you don't know where the ITO was issued? For the two kids.
ITO is an affidavit sworn in to get a search warrant.
Right. The two kids from the island who went on a rampage a few years ago, that's maybe not fair, but they both ended up dead. Schmugelsky and I can't remember the second fellow's name, McLeod. We had to look far and wide to find out where those information to obtains were actually filed so you can fill out the form. So it's not obvious. There should be a record you can go to and see if a search warrant has been issued and have that record, but it's not obvious sometimes where to find that. And that's the first thing they ask for. What record are you looking for? And give it to me with specificity. So that can be a trip up. And the second trip up, I don't love the part about, tell me why you need it. It's a public record. I have a free speech right. I'm a journalist. But so anyway, that to me has always been a little bit troublesome. And then the Court of Appeal form at this time required you to sort of speculate on who might have privacy concerns. Which again, I don't love that part of the form either, but look past all of that. Think of it as a trigger to someone, somewhere, maybe everyone in the courtroom, just to flag that you're looking for things. And I don't think there's anything wrong with saying I'm a journalist and I want this so that I can cover these proceedings, which are public. I don't think you have to explain why you want it. I don't think you have to explain.
I
what
would
you
say,
wanna
I would
do
say
with it.
less is more, actually.
Yeah.
Don't, my advice, and Rhianna, Rumina will correct me, but keep it really simple. And, you know, if it has to be a little bit even waxing poetic about courts in Canada are presumptively open, period, that's fine. That's even maybe a little bit cheeky. But, you know, in my experience, it's either a non-contentious exhibit and you're going to get a rubber stamping from the judge, likely because you've already canvassed this issue with counsel, or the judge is going to say, you're going to have to speak to this. And what you write or don't write probably isn't going to change their mind unless Lizzie Gumshoe writes something really weird and offensive, in which case she might get trouble. Like, I want to manipulate and doctor this exhibit and put it on the internet to spread fake news. You're probably not going to get the exhibit, but if you just keep it simple, one sentence, you know, you're probably good.
Which is where the accreditation process is helpful.
Don't be a
Like for the-
bozo.
You know, for the form that I carry around, you know, car keys, lipstick, and form to get exhibits. This is in my purse at all times, everywhere I go. This form, anybody, so it's called Court Record Access Request Form for Criminal and Civil Proceedings. Anybody can file this, even the public. But when you're accredited media, it helps regarding when you're checking off the box about what you want to do with the exhibit. Are you just looking to, do you just want to set eyes on it? Do you just want to listen to it? Do you want to publish it? Right? So that changes things. So I find, and again, I don't know, I can only speak for myself, that it helps to be accredited media when you have that form. As accredited media, you can just walk up to the clerk. You know, that relationship is helpful because they know, okay, she's a working journalist, she's accredited, she's got the credentials. So it is useful to have. And in that case, I just put, you know, I want these items. You don't have to get specific about, you know, exhibit C2-1, right? You talk about, I'd like photos of this, video, audio. Sometimes you say, I want all photos and video and audio. So it's kind of a Hail Mary application. It depends on the judge. And then you say it's for publication, for global news, and that it's in the interest of the open court principle, period. I don't get into specifics.
We're going to keep it moving so we can get into some more substantive stuff, but
Before you do.
before I keep it moving, Mr. Dawson.
Yeah. To Rumina's point, you can see Ian has put here as, you know, as an accredited journalist, I request. I just wanted to say this before we moved on. If you're covering a murder trial, I hate to say it, but you people are the fleas on the tail of the dog. The judge wants to have a fair trial. Someone's liberty is at stake. The defense counsel want to keep their person out of jail. The Crown want, you know, you guys are noise. So you have to go with that in mind. You can't sort of muscle your way in and say, I want to deal with this now, because guess what'll happen? You won't really be well received. So talk in the corridor, give them a heads up, you know, before you come, give them the access request. Here's an idea. Look at, guys, I know this is not your brief, it's mine. I know you guys are working really hard on a very important matter and I don't want to interfere, but can you talk amongst yourselves about when I can have 15 minutes to see if we can get these exhibits sorted?
We love to ask questions.
Why not?
I'm just curious to hear from both Dan and Scott on this fundamental question, because either there is an open court principle or there is not. And everything that you're describing, everything that you're describing is really a set of examples of the courts, both possibly coming from the level of the judges, but certainly through the bureaucracy of the courts, not living up to the legal principles established by the Supreme Court of Canada under the charter, and there is an open court principle in this country.
Yeah.
And so I get that you need to form relationships and you need to not act like a jerk and you need to ask for things nicely. But at the end of the day, all of the obstacles that you're describing exist even when you form relationships and act nicely and don't be a jerk. So does that trouble you as media lawyers and as people who theoretically are making arguments every day about the open court principle?
It's not theoretical. It's the reality. Dan will have a different point on this, but in Canada, we're all about compromise and balance. And the Supreme Court of Canada said a long time ago, there's no hierarchy of these charter rights. So you have a charter right to a fair and public trial. You have a charter right to free expression, and they have to be reconciled. And it's a delicate balance. And a bull in a china shop doesn't usually get the kind of practical access that you're hoping for. If you want to have, this is to everybody in the room, I suppose, if you want to have, you know, a challenge to the constitutionality of the policy, buckle up, people. It's going to take a long time. But if you have a deadline and you're trying to cover a public interest matter, you just have to be alive to the reality. The court is not there to facilitate your news broadcast. The court is there to have a fair trial. They work very hard at that. And if they get it wrong, the Court of Appeal sends it back for another one and we all have more delays. So, I mean, I take your point. Do we have free speech? Do we have court openness? The answer is we do. It's a balancing in every case. And it requires tact in every case. And I'm sure you'd be the first to recognize that because I happen to think we've come across each other in the past. So yeah, that's my 2 cents on that. Yes, we do have it. That's why we do these things. But the court is trying to balance something that the court will consider to be probably more important, at least as important as helping you get exhibits in a timely way. And don't be surprised if you are a footnote. And I think if you approach it that way, in a fair way, I just need 15 minutes. I know you folks are all trying to do your very best on a busy brief. Can I talk to you in the hallway as you walk for coffee? You might be better off than a full frontal assault on the constitutionality of the court policy, which didn't go well for me. Dan?
Yeah, I mean, I think Scott's grasped it completely. Desjardins, I think, was the case that said we reject the clash model. That's American. Here we balance. You got your fair trial rights versus your freedom of the press rights, and we balance them. So what does that look like every day for lawyers like Scott and I? We're not denying your ability to publish. We're delaying it. You can't have the audio recording of the 911 call. You can have a transcript. We'll give you the CCTV footage, but you're blurring just about everything in it. See the theme here? It's compromise, and in some sense that's good, but it's also, as certainly I've argued and failed, it's compromise to the point of depriving the public of what was actually before the jury or actually before the court, and now someone's in jail for the rest of their life, you know, and getting access to an exhibit 6 months after the fact. Well, what's that, right? But we can talk more about that after 7 o'clock. Before you get off this slide, so Rumina, what was the name of this form? Court Record Access Request Form. Google that, and you can find a copy of the form. You don't have to be like Rumina and keep one in your purse or your briefcase, but you should be familiar with it. The other form that's up there is a Form 17. If you Google BC Supreme Court Civil Forms, Form 17 is a generic requisition. And the point I want to make is, if the judge has rejected your request form and says you need to speak to this, sometimes you need to file a requisition, which is connecting in the court file a rejected access form with scheduling of a time before a judge. So all of this sort of loops back to, you need to be in contact with the court clerk and counsel to know when an appropriate time would be to schedule this hearing. The judge just says, nope, you got to speak to this. Okay, so what's set up here is filed by Global News, filed by Lizzie Gumshoe, required. Justice so-and-so has asked that I speak to my request form. That's what's required, and I want to do it at a certain time, supported by my filed form, whatever request. So just be familiar with these forms. You know, we don't have the time to tell people exactly what should be in them, but be familiar with them. You may need to use them. Okay, Vinny, let's go to day 3.
Okay, day 3 of the trial. You duly filed your request form and you're shocked and dismayed to discover that this is not the first thing on the judge's mind when court resumes in the morning. The Crown is about to call a witness who was in the wig and gown on the night of the murder and is asking that a publication ban be ordered over the witness's name and any other information that could identify him. Crown mutters something about this ban being consistent with an earlier ban and, quote, witness safety. You believe this witness is going to have interesting evidence and you wish to link his testimony to the photos you're hoping you could get access to. So what do? Leap to your feet to oppose the ban, ask counsel at the break to clarify the ban, or check for earlier bans? So we have one last poll here that we're going to launch. It's just asking who is familiar with the RSS notification of media and public of publication bans. So I've just launched the poll on Slido.
Rhianna, why people are dealing with the poll, who at CBC monitors the RSS, if anyone? Is it useful? Does it inform your practice allocation of journalists?
I would say generally some reporters do, but we find that it's not 100% reliable. I wouldn't use it as like the Bible of publication bans and say, I didn't see it on RSS, so it doesn't exist. So we use it, but really quite carefully. I wouldn't say it's the best way to try and determine if there's a publication ban for 110% certainty.
And just for people who don't know, it's the simple version. It's a notification system that's set up by the court. And again, on the court website, you're able to sign up for that.
How did our poll go?
50-50.
50-50,
Yeah.
okay. So this is great. Again, I put that poll in there mostly for curiosity. Again, half the people here tonight didn't know about it. Register for it. You've heard it straight from Rumina and Rhianna that it's so as far as usefulness as journalists, but it arises from practice direction 56. Again, I'm not going to ask Vinny to flip that up, but what practice direction 56 sets out, and again, please Google this, it's all available, is that for discretionary bans, so that's not an automatic ban and it's not a mandatory ban, typically Crown or defense who are applying for it need to give the media by way of the RSS system 2 days notice. Do counsel always do that? No. Do most judges care if they don't? Not really.
Well, maybe to come to the defense a little bit. So this is a syndication service called the Really Simple Syndication. I think it's a push notification if you sign up for it. And if there's a ban coming up and people follow that, and in my experience, most people do follow that, there'll be a notification that someone's going to apply for a ban, in this case, in that day. They might not give you a lot of detail about what the ban is, but at least you'll know in a case, you know, that you're covering maybe one of the Bacon cases, oh, someone's going to apply for a ban. And you'll know that that may, you know, be of interest to you. Again, going back to the judge who comes in at 9:30 or 10 in the morning in the courtroom with a full group of people, and the first person says, I've got a ban application today. And the judge says, and many of them do, it's a fantastic thing that this has come so far. Well, have you notified the media? And then someone will say, well, no, I haven't, but for this reason, we need an interim ban or whatever. A lot of judges will give an interim ban and then say, I want you to go and notify the media.
That's right.
And they do that because they know it's important that you cover the courts. That's how they have credibility, you know, with the general public, is when the general public knows the good work they do every day. And, you know, they work very hard every day. It's just there's a practical reality when you have a room full of lawyers and you're delaying a trial and someone says it'll take 5 minutes and you say, no, notify someone and then we'll all come back a week from now and we'll schedule something else. There's a momentum to those things. So a lot of judges will say, well, let's deal with it now, but I'm going to require you to give notice. And if anybody opposes, we'll come back and talk about it.
It's setting it aside from, we'll give it to you now, but because you didn't notify people,
Right.
we're going to set it aside on very short notice.
Yeah, I was just going to say, I think we're going to get to contempt of court in a minute, but in terms of the RSS notification, I think the stakes are way too high for a publication ban to rely just on that system alone. Like you want to, it's very, very, very important to know what's what when it comes to a publication ban. So we'll get to that, I guess, in our next point here.
And Vinny, could you just move to the next bullet as well, just for one other policy I want to flag?
Yeah.
So again, we're not going to read this policy. This is a very new policy from Associate Chief Justice Holmes. It became effective on August 8th. And this has been something the media bar, and I think everyone in this room has probably been hoping for a long time. It's a directive now that publication bans should be reduced to writing. And if you come to court looking for a publication ban, you should come with a draft order that sets out the authority. So it's a criminal code 486 ban, inherent jurisdiction of the court type ban, and what information needs to be shielded from publicity and what specific details are included in that. And they've even enumerated the classic example of, do we need a publication ban over the accused name because that would necessarily identify the victim, which happens with some frequency. So again, that's set out in the policy. And it goes on to say, again, with generous language, like wherever practical, at the end of the day, the judge and the court clerk should make sure that a publication ban is reduced to writing, and that would find its way into the file. And you could ask Crown or defense. So why that's important, of course, is if you were sitting in the cheap seats and a pub ban was just ordered because you didn't do a Rumina Daya and jump up and down and say, I want to oppose this right now. She can talk about that in a second. You can, at the appropriate break, ask for a copy of that order and know that one should be available. Prior to this practice directive, certainly in my experience, that was not always the case. It's also very useful, and I know Rhianna can speak to this, if you've just been dropped into a long trial and you haven't been there from the get-go and you're whispering in the gallery, what's the pub ban? You know, what can I say? And everyone's kind of shrugging. Someone should be able to go to the court clerk and say, hey, where's the written record of all the bans? So this is still pretty new. I haven't seen the benefits of this directive yet.
Can't hurt.
Yeah, I mean, I'm hoping there's a lot of good that comes from this.
Well, and also when you're dealing with the clerk or counsel or the registry, get the section of the ban and find out who specifically it applies to in your case.
That's going to be our segue to the next slide.
Contempt of court. It's very important that you understand the limits on what you can publish. That doesn't mean you can't be creative. Contempt is risked by a breach of a court order or the criminal code, or generally publishing information that poses a real risk of prejudice to a fair trial. So there's two examples of media found in contempt and fined, and I think Dan will go over these two examples.
Scott, do you want to just speak generally? I put up two cases, RVCHBC and the Queen versus Province. Whether or not you want to refer to those cases or just speak generally to the pitfalls and concerns and importance of knowing the pub bans, knowing the 648 regime, which is that you cannot publish anything that was said in the absence of a jury in a jury trial. That's a big one. And the consequences. Do you want to just deal with this?
Sure. Sure. The consequences can be a criminal charge against you. So if you want to go to Hawaii for vacation, you might not be able to. That's a rare thing. Usually it's the media organization that gets charged, but it's a criminal charge. So you just can't take chances with that kind of stuff. Rhianna said that earlier. You can't just rely on an incomplete RSS feed to think you've got it all covered. So why do we have these bans? To preserve the fair trial rights of the people whose liberty is at stake. Like, it's an important matter. So a cavalier approach to whether there's a ban is going to get everybody in hot water. And frankly, rightfully so. Now, I think probably the participants in the judicial system could do a better job sometimes of reducing these things to writing. But remember, they're trying to run a fair trial for someone whose liberty is at stake. So they're concerned with weighty matters that maybe aren't, you know, at the top of their list isn't, I want to make sure that today's order was reduced to writing and so forth. So it's critical. Contempt is it's one of those kind of vague matters that, you know, you ask a lawyer, is this contempt? And the lawyer says, well, it depends. It depends. But what I would say is when the police have called you and said you've done something wrong, that's the police not coming to you as someone that they see every day or they've met before in the courthouse. That's the police investigating a possible crime. So it's really no different than the police investigating any other crime. They're trying to get a statement from you. They're investigating a crime. So, you know, be cautious about that. Be very careful with these pub bans. The last thing you want is to have a jury trial that's been going on for 3 months, you know, somehow now be at risk because of something you published, because you were parachuted in on day 6 and you didn't know on day 3 there was an order. So, I mean, it's not for the faint of heart. I know some people in this room have taught media law. It's not for the faint of heart, but you really do need to be very careful if there's an order or possibly an order.
Mm-hmm.
And that's where these two, you know, have their spider sense. Oh, I know this is a sexual assault case. Well, boy, gee, I know there's probably 5 areas here where I should think there might well be a ban. I should probably look at that. And I guess I'll ask you, Rumina, is that something you deal with every day? I know this kind of case and therefore there must be a ban of this sort.
Yeah, there are bans that are standard bans, right? Your identity bans in a sex assault case, depending on the charges, right? Your bail hearing bans that you can't, again, in the fairness, right? The defendant is fighting for their life. And you can't go now and publish, you know, while they have a bail hearing, all the background and all the details before a jury is even chosen. So so bail hearing is off limits. And on the eve of trial, speaking to contempt, on the eve of trial, say you've done a story 2 years prior, and all of this information came out in the story at the time, right? From the police investigation, from talking to sources, witnesses. On the eve of a jury trial, you have to be very lean on what you publish.
Right.
And you can't say, oh, well, you know, this didn't happen in court. We did it 2 years ago. That could, if that influences one jury member potentially, you have a problem. So you have to be super careful about. This happened in Ibrahim Ali, right? The case of the 13-year-old who was raped and murdered in Burnaby Central Park. And we're talking 7 years ago.
Mm-hmm.
So we've been covering that story for 7 years from day one, right? And then you get to trial. Now there are all these bans, all these competing interests. You have to, there were all these allegations that came forward regarding DNA evidence at the time. So you had to be super careful. Cornelia could speak to this after as well from the Burnaby Now. We're constantly discussing this as journalists during the trial. Okay, well, can we say that? But what about this? And so you need to, and again, it's easy for me to call you up and say, what do you think about this? Should I delete anything?
But you work for Global News, Lizzie got.
But that's what I mean. So you know what,
yeah.
as a journalist who doesn't have the Goliath behind you of a major news organization that's got lawyers, talk to another journalist that's on the trial, right? We did that, right, Cornelia? We would talk about it and we'd say, what do you think? You know, what's your advice?
So
People
here's
are
some
willing to help
examples
you, right?
of
So
things that the journalists in the RVCHBC thing did wrong. So they reported on a mistrial application, which is a huge no-no. Defense counsel were making submissions to the judge about all the different ways this fair trial has been breached in the absence of the jury. So telling the jury a whole bunch of things they wouldn't know. saying things that the jury wouldn't know. And CHBC reported on it. CHBC, to Scott and Rumina's point about the uncertainty during the jury trial, we're 18 days in, this is a mistrial. So the amount of money and effort lost here is substantial. And they had to move the trial from Vernon down to Vancouver. But CHBC was playing Crime Stopper videos from years prior that involved reenactments and photos of the scene, none of which was evidence before the jury, but was absolutely, of course, on point and prejudicial, was playing that during the jury trial. And then despite defense counsel saying, my client is being paraded around the Vernon courthouse in shackles and handcuffs, that's prejudicial to him. Can we talk to the sheriffs about making them not do that anymore? That sort of stuff was then rebroadcast by CHBC. So all of these things that were not necessarily clear contraventions of 648 were just things that someone ought to know would impact the fair trial. Because of course the jurors aren't impaneled at this time. So they're watching the evening news and they're seeing all of this information that they had no idea about. Terrible stuff. And on the province 2001 case.
Sorry, CHBC, were they charged criminally?
Yes, they were fined. Yeah, they were found in contempt. Yeah. Now part of Global, of course.
Yeah.
And then just briefly on the province case, a accused person was indicted for 2 different murders. And his counsel said, well, I need a publication ban over this so that jurors don't know that my guy is accused of doing 2 different things. And had set that publication ban for, I don't know, the next day. And the province ran out before the publication ban was going to be heard and published that. And Justice McEwen did not appreciate that at all. So spidey sense, common sense,
Experience.
Yeah, I would just say really quickly as a good rule of thumb to remember, if you're ever covering a jury trial and at any point the jury is let out of the room, they are taken away, and then counsel are discussing something with the judge, that's generally a big danger zone.
Exactly.
Like,
Yeah.
that's just something to watch out for. If the jury ever leaves, that should definitely set off a red flag in your mind.
If the jury didn't hear it, you can't report it. Is a good rule of thumb.
You know what was the fine?
$5,000. $5,000. It was a criminal conviction.
Right.
A criminal conviction for a news organization is probably more
Yeah,
important
no.
than a $5,000 fine. But
And of course, the journalists were named, like these reported decisions, if you guys look these up on Canly, as I'm sure you can, you know, these guys and girls and their newsroom editors, they're all named in there and they all had to explain what they did and they have to apologize. Like, you know, maybe the money, I don't know what $5,000 in 1997 was worth, but
It's your credibility.
it's your credibility. I mean, you're red-faced and these are pretty major blunders by blue chip news outlets. So the cautionary tales that just even the big players make mistakes sometimes. So again, if you're Lizzie Gumshoe and you don't know a lot about this, talk to your colleagues, take Rhianna's advice, and if the jury's out, don't broadcast things they didn't hear. Okay, we got to talk about day 4.
Okay, day 4, you are having a bad day. The judge has returned your access request, wants to speak to it in court. Worse, counsel for Mr. Frump told you they oppose the release of the photos of the murder weapon. Crown Counsel has handed you a form of order confirming yesterday's publication ban, and it is incredibly broad. Names and information that could identify any witness who was in the pub that night. So what do you do next and how do you do it? You need to get before the judge to speak to your exhibit access requests and set aside or vary the publication ban. You have to be patient. It's a jury trial. Everyone is busy. You also need to speak with counsel to coordinate a time that is convenient. There might be down days or mornings for housekeeping matters. And lastly, file a requisition.
And can you do the next slide as well before we take a break to speak?
Yeah, so here's just some tips for speaking court. Organization is key. Prepare something in writing for the judge and for counsel if you can. Speak slowly. And judges are cautious by nature, and especially about media requests. They don't want to jeopardize their jury trial. And most judges ultimately do support the open court principle.
Okay, thank you. So we've already covered some of the stuff on these 2 slides. We covered what an access form looks like. Anyone in the room can fill it out. You can handwrite it. You've sent it up. The judge has said, okay, you're going to have to speak to this if you want a photo of that really unique looking murder weapon. And you filed your requisition because you talked to counsel and counsel told you actually Friday morning is our housekeeping day. So why don't you file your requisition and plan on speaking 10 a.m. on Friday when we're dealing with a bunch of other stuff. So Rumina, let's start with you. I know you have done some successful speaking in court. What can you add for a journalist on his or her own getting up to the lectern and playing lawyer?
Well, success because of you a lot of the time, but it's intimidating. It's intimidating to, you're a journalist, you're not a lawyer. So, you know, this is why you try to head it off by finding out what the opposition is so that you can make some sort of logical argument to support why the public should have access. So, you know, privacy comes up a lot. That's the new word that gets thrown around a lot. You'll get into that with the latest case law on that every journalist should familiarize themselves with, Sherman Estate. So, you know, I always preface my comments to a judge that, hey, listen, I'm just a journalist trying to do my best. Please have patience with me. I'm here on behalf of the public. And as I said earlier, that I'm conducting a trial in the court of public opinion, and it's important that they get to see these. In my opinion, it's important that they get the same access the jury does, because they're the judges of whether the justice system is working properly. They're the judges, the public, they're the ones who are going to judge whether there's accountability, transparency, and fairness in the justice system. And they can't do that if they don't have the same exhibits that have been played in open court, that anybody can walk in and see, that the jury is also considering. So you go in, you speak to what you want. Again, if you know that there's going to be opposition because you did your homework ahead of time, always have a remedy to offer the judge. So if you wanted 12 pictures, for example, you know what? You know what, Your Honor? I don't see any privacy interest here, fair trial rights issue with these, in my opinion. What if you give me these 7 and we take these other ones off the table? So a judge likes to see that you're willing to compromise. Counsel likes to see that as well. And again, when you're talking about timeliness and wanting it for your 6 o'clock broadcast that day, and you don't have time to launch, you know, like to get an official hearing and get materials ready, you know, you have to get it done that day in the moment. So I try to adhere to the keep it simple, stupid rule, the KISS rule. Don't talk too much. Just defend your position about what you're after and then be willing to bend on certain issues.
Scott, could you, I circulated a draft or precedent model sort of written submission. Scott didn't prepare this, but Scott, I wonder if you could in 2 minutes just talk generally about the structure of a notice of application, sort of the relief sought, factual basis, legal basis, like what, I can give you my copy if you want, just kind of what people should have a hard copy. A PDF has been emailed around, but maybe Scott could just orient people to what a notice of application looks like, why there's those distinct components and sort of how they operate.
So this is a form that we all know and love, and this is a request for a court to make an order. I go back to an earlier slide. I think it was read out that most judges appreciate the open court principle. I think they all do. It has different application in different cases, and you have to be aware of that. So when you're at the stage where you're filing this application to request information from the court, I would say maybe 3 things. 1, shorter the better. 2, not really a place to write a long legal argument. It's really, here's what I want. I know there's a section for legal argument, but you don't need to be exhaustive there. You can simply say, look, Sherman Estate has said this is is presumptively a public proceeding. Here's your court access policy. It says I get these things for these reasons, and I would like them. So first, short. Second, direct. You know, when I was called to the bar, it seems like a long time ago. Thank you for reminding me. You know, the very first thing you do out of law school is you start to say, oh, I want to sound like a lawyer. Wrong, wrong. Be straight, be direct, be short. So I would say A, short. B, be very direct. C, ask right up front, this is what I want. I would like you to make this order. I would like these 12 photographs. Don't wait till the end and sort of have the judge say, now I've heard you for 30 minutes. What exactly are you after again? So that's what this form is designed to do. It doesn't need to be legalistic. The reality is we're long away from the time when every news organization had lawyers who could run down at lunchtime and make submissions at 2 o'clock. I've done that. Dan's probably done that, but it doesn't happen very often anymore. It used to be a staple in my practice. So you're going to find yourself doing these things. So, but if you can keep those kind of 3 rules in mind, you'll have a better reception by the court. So short, right? Short, be very direct, and upfront tell the court what you're after. Doesn't have to be a great big legal brief, because you can rely on the court openness rule, and you can rely on Sherman Estate, and you can refer to the court policy. And I think every single judge sitting in this province, I don't know about any others, knows you have a job and knows you have rights, and within the realm of the reality they're dealing with, they'll try to accommodate those rights. So I don't think you have to be afraid that you're going to have someone aggressively questioning you. That's not been my experience.
Yeah.
Counsel get that, but the judge probably is right to expect of counsel a thicker skin.
Scott, could you give us 5 minutes on Sherman Estate? And then that should give us about 10 minutes for questions.
Sherman Estate. Okay, so starting from Dagenet, and that's 1996, or I think maybe 5, something like that. Court openness, you have a prima facie right. There's a test about when there will be a restriction on court openness granted by the court. Everybody tries to get themselves into that test. Journalists try to avoid getting people put into that test. Every few years, it comes back to the Supreme Court of Canada. They tinker a little bit with it. The latest tinkering is Sherman Estate. I don't really think it adds that much to the pre-existing jurisprudence myself. You know, there's an unbroken chain of almost 30 years of courts are prima facie open to the public, and you get these things. The wrinkle with Sherman Estate, the wrinkle is that in that case, the reason for the request to restrict court openness was kind of a new and novel and emerging thing called privacy. And the Supreme Court of Canada was trying to reconcile, how do I deal with that? And it did it in this case by saying a privacy interest, if it rises to the right level, can be a reason to get a restriction on court openness. But it's not just, I want this to be kept private. It's got to be a much higher standard. I think there's a slide behind me which sets out sort of a reformulation of the access test. Sorry, it's not the access test. It's the test to get a restriction on court openness. And so, you know, Sherman Estate is known now by every judge in the province.
Yeah. Sure.
And you won't have to spend a lot of time on it, but it's useful to have that. It's a Supreme Court of Canada case from maybe 3 years ago.
Yeah, 2021.
There we go. And I guess that's all I would have to say about that.
Okay. Rhianna, you get the last word before questions on anything we've spoke about tonight.
Oh, God.
Any advice for Lizzie Gumshoe trying to get exhibits or speaking in court for the first time?
Yeah, I was just going to say on speaking in court is not to be thrown by the legalese. Like, as you said, the language that counsel use, like they call each other my friend. They just speak in a totally different language in a way. You don't have to worry about that when you get up to the lecture.
Speak plain.
Just
Yeah,
speak
don't need to.
exactly as Scott said, just what you want, why you want it, respecting the space and respecting time in the space and being succinct. Like I've seen Rumina do it, where she's gotten up on behalf of the media, like CBC, CTV, other papers. And she's very good at just saying, you know, we, the media, this is what we want. This is why we should have it. It's, you know, in the interest of court openness, and that'll be it. And then I think we've had to remedy, as you've said before, I've seen where you've offered remedies, where we wanted a video, for example, and we've agreed to blur some of it, things like that. And I've seen you be successful at it, and that's really the recipe, I think.
Yeah, but, and exactly, like, again, KISS, most important. Just keep it simple, be confident, know what you want. And then if issues come up, then you offer it. You don't throw all that out on the table the second you start. You should be just a couple of minutes and period. And then be prepared. Again, after reading these cases, you don't have to recite paragraphs to the judge, but it just, if it
Don't
gives you an
recite
idea,
paragraphs to the
yeah,
judge.
exactly. You're not a lawyer, as I said, but it gives you an idea of the issues that will come up, right? Privacy is a new one that I hear all the time, where, well, we oppose because of privacy. And then, but there's no evidence. There's no, they're not specific. It can't be just hearsay, right? So again, you might not even have to get there if you've had conversations with counsel and they're not opposing anything. So if you know that their positions are that they're not opposing anything, your opening to the judge will literally be maybe 60 seconds, 90 seconds, boom, done, application granted. And just so you know, once it's granted to one media organization, then it's basically there for everyone. So if, again, accredited media, this is helpful, because say Global News gets, I make the argument, my 7 out of 12 photos are granted, then say CBC, Rhianna comes in 3 days later and says, hey, listen, I just got thrown in on this trial. Do I have to go through this whole process? No. She takes the application, files it at the registry, and then she gets access to what's already been granted. It's just a quick sign off rubber stamp from the judge, and you're done.
Vinny, maybe you could put the further thought slide up and then we can just take questions, because I see we're very close on time.
Yeah. I think I'll just leave that up there.
Yeah, leave that up there. Absolutely. Yeah.
And then I think, do we have any questions online, Christine?
One question.
Mhm. My brother question.
So just, yeah, one question online. Will the new directive on publication bans be retroactive for ongoing cases?
Doubtful.
Very doubtful.
Yeah.
And to be clear, that it's a practice directive. There is no one policing judges that they absolutely have to do that. As Scott has stressed, especially in a case like an ongoing jury trial, judges are very busy, counsel are very busy. They should come with a form of order. That form of order should be discussed and settled and signed on the bench and entered. Ideally, that's not always going to happen. And certainly there is no bandwidth in the system for judicial figures to be going backwards and doing that. I think if someone is interested in the terms of publication bans that were made previously, you're looking at DARS, maybe you could bring an application to get some judicial direction on that. And even then, I think a judge may come in to a courtroom looking frustrated and looking to Crown Counsel. So I think it's going to be a great benefit going forward, but it's not going to be that helpful for older cases that you're looking at to report on.
My favorite is when they pronounce a publication ban, then they seal it in the file.
Right. Right.
I'd like to see this ban. I've literally had this experience at the counter with a journalist beside me. Is there a ban? I can't tell you. Well, I'd like to know if there's a ban because so-and-so here, Rhianna in this instance, it wants to, comply with the orders of the court, but needs to know what they are. Well, you'll have to apply. So, I mean, it can be a bit Byzantine. This is definitely going to help that.
Yeah.
Definitely going to help that.
If we have questions in the audience, Janet will be passing around a mic just so that people online can hear the questions as well.
Hi there, thank you. When it comes to applying for exhibits, how specific do we want to be when we're saying whether they're for publication or broadcast or for our own understanding?
Well,
And there are follow-up questions here.
that's probably for these two more than me. You already heard me about balance and about where you fit in,
That's right.
right? But here, I don't think there's anything wrong with saying I'm an accredited journalist and I want these for my job, period.
Yeah, you could start with that and keep your hopes high. I've found previously in a video instance where we'd asked for a video, there were different tiers of release. So they said, we can't give you the file, but we can bring you into a room in the courthouse, lock you in there with a DVD and let you watch it. And then you can take notes on what's visible in the video, but they wouldn't release it. So I would start by asking for all of it, but in the end, we did have to, as Rumina said, agree to a remedy where we can only watch it and describe, not actually get access to the file. So I would say shoot for the moon, but
You do have to specify.
yeah,
So I'm
there's
just
like
holding up-
a tick box, isn't there? I
I'm
think?
holding up the form right now and so you do have to specify. You don't have to write War and Peace, but you do have to specify. So it says level of access requested, unlimited, right? For view, listen, copy and publish, which is what I always tick. There's view, listen and copy, right? There's view and listen only and other, if you want it for some other reason, right? So you do have to specify whether you want to publish or, maybe you're just checking your notes, like a trial is starting and you want to go back to listen to something from 2 years ago. And so it's just a matter of accessing the audio recording and you just want permission to be able to listen to that. And now there's also a new system that, which the courts have done a really good job and listened to us on this point, that, if you've got a journalist in northern BC and they're asking for an exhibit from Vancouver, it's difficult. How are they logistically, how are you supposed to get that? So there is a system now, again, if you're an accredited journalist, they have a secure file transfer system within the courts where they'll just send you the audio. They'll send it to you via email. And there's an expiry date on it, when it's not going to exist anymore. And then, of course, you adhere to the fact that it's just for listening purposes and not for publication.
Love the DARS. Then the practical follow-up is when the judge says, yeah, you can have the video, but I don't want you showing the moment, like when, a traffic incident, the person is actually struck and killed or something like that. What's the practical thing you do on your feet to see that you still get the video and you can use the stuff, but leave the judge assured that you're just not going to use that?
So I've never experienced a judge ever telling me that they don't want me to use something, right? Like where the judge says that I think it's inappropriate, that this goes to air. A judge is not there to weigh in on that, right? So if counsel, again, that's why you need, it's valuable to have the position of counsel. So we had one recently where that happened, in the Alfred Wong case, the 15-year-old who's in the back of his parents' car and is hit by a stray bullet coming home from dinner with his brother. It could have been anyone's kid. In that case, the shooting is happening on, this gang shooting's happening on the street, and the gunman is shot from across the intersection from quite a distance away. And it was blurry video, but the gunman is shot and he collapses and dies. So in that case, I asked for the video. And then Crown had concerns regarding the family of the deceased, of the gangster, that of having that just out there with seeing him collapse. So in that case, I'd already spoken to my newsroom about where's our remedy? Where are we willing to go with this? Do we need to say, no, we disagree, and then you have to file for a appeal of that decision? But the newsroom said, listen, we're willing to cut it off at that point. If it means you're going to get the video that day, we're willing to provide that remedy to the court where we'll do that. And so, and again, to a lot of the times, the lawyers, registry, they don't have the time or the capacity to do those edits. So you give the judge your word as you're there talking to them on the stand that you will make sure that you abide by whatever she orders. So she orders then, based on the arguments from those opposed to the entirety of the video being out, if they say that, well, okay, we're okay with that. Opposing counsel says we're okay with the video going out to the media in the interest of the open court principle, but we want that part blurred, that moment blurred. Then you agree to the judge's, whatever the judge decides that she's going to order, and then that's what you do. You end up treating the video yourself. And then you're ready to go for publication that same day.